the court did in its recent ruling, as per the challenges brought against the Attorney General representing the state, was to simply qualify the law insofar as Section 14, which deals with gross indecency, and Section 16, which deals with rape. When I say qualify, what do I mean? Reference to the challenges brought, and there were many challenges brought, and just now we're going to hear from the Senior State Counsel, who will give further context to the ruling and the challenges that were brought against the state. And in many of those challenges, the court agreed with the state. Should reference that so far as it relates to one's rights to freedom of association, freedom of expression, one's rights to security, and the whole notion of one's right being violated on the basis of sex. Our Constitution does not reference sexual orientation, so there's no justification in the circumstances to have brought such a challenge against the state and to have succeeded. But Mrs. Sobers will give further context to that. So, what is the ruling in a nutshell? Is that two adults within the confines of the privacy, two consenting adults within the confines of the home of privacy. The police cannot bring charges against them. They are within the confines of the homes and they have consented. The misconception that burglary only speaks to an act in that form, I don't like using the word, between man and man alone is false. Our Sexual Offences Act, which is one of the most comprehensive in the Caribbean, also, before that ruling, penalized two adults engaging in that kind of activity, even if they were within the private space and they consented, they also criminalized that act between male and female. Now, what is the law? So, burglary still stands insofar as it refers to one, minors. That's to say, a minor is defined, according to our laws, below the age of 60. And as per our laws, a minor cannot give consent. So even if the minor were to say yes, that is not consent as per our laws. And then the penalty for that is 25 years imprisonment. That still remains on the book. If you're an adult and if that such activity, anybody violating you, be it a male or female adult, without your consent, that is burglary, and you'll be charged by the police for that. At absolutely no time is burglary or gross indecency permissible within the public domain. Even if you were to consent, you're two consenting adults, you cannot be involved in that activity at a public washroom, in the bamboo house in the gardens, anywhere within the public space. That person or the two people will be arrested. I want to set your question with that. Let me just say further that this is not a lifestyle I subscribe to. Neither I will ever subscribe to. But the parent law of the country is the Constitution. And if we were to make a reference to some of the sentences and quotes within the forewords of our Constitution, which says that the Constitution of the Commonwealth of Dominica is founded on the principle that acknowledges the supremacy of God. It goes on to reference the position of the family within a society of free men and free institutions. It goes on to say and speaks to the guaranteed rights of citizens within the Constitution, which means, therefore, any member within the society who feel aggrieved and who believe that any law enacted in Parliament is not intra-virus, that person has a right within a democratic society to challenge that law. And let me say also that there were similar rulings in countries with similar social and cultural realities and similar laws. I would reference St. Kitts and Nevis, Antigua, Trinidad, Barbados, and Belize. That notwithstanding, and we have to also understand that over the years, since our independence, our jurisprudence as a country and as a region has emerged. Laws will be challenged, courts will give rulings on those challenges, and that will constitute precedent. Once precedent is established, you're obligated to follow the ruling of the court until that ruling is challenged or it falls. And even if we do not subscribe to a particular lifestyle, but within a democratic space, we have to abide and comply with the rule of law. The notion that it is the government and poor Honorable Rivers Carey who legalize burglary or gross indecency is malicious, is wicked, and fundamentally misplaced. We also have to have an appreciation for the separation of powers. What we did, I was a minister then and I'm still a minister. 2011, we met with all the relevant stakeholders, spearheaded by Mr. Ray Harris, a distinguished draft person in the Caribbean and the world by extension. And we examined critically the 1998 Sexual Offences Act. And we significantly almost rewrote the entire act, and expanded the scope of a number of offenses that were not previously in the 1998 statute. That is what we did. Before that, our law did not speak to issues like grooming, which of course protected our minors. What do I mean by grooming? Some of us like to use cell phones and to send messages. So if you were to use a cell phone, well, like WhatsApp, and communicate anything that can be inferred to as a sexual inducement to a minor, that is grooming, and you can go to jail. One of the elements I want to stress before I call on Mr. Sobers is that when we passed the Sexual Offences Act, Dominic was heralded by Commonwealth Secretariat and a number of international organizations, to the extent to which a delegation including the Speaker of the House and myself, were invited to this Commonwealth Secretariat to share our experiences with the rest of the global space as to how advanced we were when we criminalize the whole issue of husband or wives. Before that law, a wife could not have said no to her husband. It was okay to have forced your wife to have sex, whether she was sick or no. Not sick. We criminalize that. This isn't a law. It was not there before. Likewise, a wife cannot force her husband to have sex. That is criminalized. That is how far-reaching we went to Parliament in 2011 and to enact basically almost a new Sexual Offences Act. Because we are minded by the fact that our society, our parent law, speaks to the supremacy of God. And that is why the Sexual Offences Act and a number of pieces of legislation within the criminal statute are drafted in a way that seek to preserve the issue of morality on our Christian belief. But the world is evolving, the world is changing, and people will challenge a number of pieces of legislation. So I call on the public and those of you who have a very important role to play by disseminating information to the public, have a moral responsibility to ensure that you're not reporting stories of birth, but you're in fact reporting the news. And news is not about you. It's about the event that you are reporting to the public. So you play a very important role in that regard. I will now, we'll have questions and answers after the various presentations. So you have all the time to get everything clarified there this morning. And I just want to take this time off again to say thank you for coming and thank you to our listening public thus far. Thank you. So as I go again, let me just say that burglary is still an offense, serious offense. I want this DPP speak to make reference to the penalties that still exist within our Sexual Offences Act. Very serious offense. Sentences. For a matter of fact, let me just say that the court does not have any discretion when it comes to issues of burglary, custodial sentences. You must go to jail unless you're found guilty. And just recently, somebody was sent to jail for violating a minor, 18 years imprisonment. That's how serious the laws are on the books, and that is what our focus ought to be. So the rulings speak to people who are protected under the act. Let me just say as I end, a minor, an adult who does not consent. So even if you're above 18 or above 16, and even if you're in a private space, in a hotel room or at home, and somebody has forced you to do that, whether the person induced you, use alcohol or drugs or whatever the case may be, or the person overpower you physically and violates you, you can call the police and the person will be arrested and charged for burglary. And I'm not sure how simple it can get. So our concern ought to be the vulnerable in our mix, and people have a right to say no. And it applies also, let me just say, male and male and male and female. There's a gender-neutral piece of legislation. So if a woman says no to a man, even if she's an adult, even if she's within a private space, and that man were to have that kind of intercourse in that part of a body, which is recognized by the law as burglary, and she makes a report to the police, he will be arrested and charged for burglary. Thank you very much.
Thank you, Mr. Honorable Reuben Blackmore, for your presentation. We will now like to call on the Senior State Attorney of the Chambers of the Attorney General, Mrs. Vanica Sobas Joseph.
Thank you to the Acting Deputy Registrar, Ms. Guyon Chuse. Good day to everyone. I wish to acknowledge, of course, the presence of the Honorable Minister of National Security and Legal Affairs, Mr. Reuben Blackmore, the Honorable Director of Public Prosecutions, Ms. Shoma Darampo, the Acting Chief of Police, Mr. Davidson Valerie, members of the media present here, members of the public listening via online or radio. I would first like to say that in this case, I wish citizens to understand that there is a separation of power. I think in social studies, way back when I learned it, we learned that there is the executive branch of government, there is the judiciary, and then there is the legislature. Legislature being parliament, judiciary being the court, executive branch of government being the government as we know it. And so Parliament would make laws, and then these laws are interpreted by the courts. In this instance, as the Honourable Minister has indicated, Parliament passed a very robust Sexual Offences Act, and that act recently was subject to a constitutional challenge. It is known, and I wish to reiterate, that the Constitution of Dominica is what we call the supreme law of the land, much as is the case for Christian persons who believe in God. Your God is your supreme authority. Now, in Dominica, the law, and in other places, is organic. The law does change as time and societies change, right? And citizens, by virtue of the Constitution, do have a right to challenge those laws. And that is what happened with this case, and that is what will and may continue to happen with any case where a citizen feels, whether it is with respect to the activities under the Sexual Offences Act, as was happened in this case, or your freedom to associate by virtue of a trade union or otherwise. You are empowered by the Constitution to challenge any law that you feel infringes on your rights. And in this case, a citizen did so, and the judgment was here to discuss and to explain in as simple terms as possible so that the media can educate persons and that you as a member of the general public in Dominica and extension overseas and as a citizen of the Commonwealth of Dominica know what are the confines of your rights within the confines of the law. That being said, I know that there may be certain persons who are of the opinion that the way the state presented their case, we did not defend the case. And I would like to say that that is not a current or correct characterization of what happened with a constitutional claim. When it is filed with affidavit in support, you would find often an affidavit in reply. And if a document in this case is seen and there is no defense written anywhere on it, I would like to clarify that an affidavit in reply, known as a defense in constitutional claims, was filed on behalf of the state. And at the time that the affidavit was filed, the state presented, and that was quoted in the court judgment, that the premise that the fact of the law being as it was then, that the law being as it was then, was subject to being discriminatory to certain members of the public or put certain members of the public in fear of how they could live their life was untrue. The police does not enter into private citizens' homes and try to regulate their personal conduct within the confines of their home. The Constitution protects that. whatever you do within the confines of your home, the Constitution will protect you in as much as a criminal complaint is not made against you. And as the minister said, for this case, if there are two adults consenting in private, the law never has, and as with this case, will not in the future seek to arrest and charge anybody for acts done by two consenting adults. And let me restate, adults, male to male, male to female, female to female. Okay? And I would like to say that as clearly as possible. Now, the minister did a very good job in explaining that in Dominica, we have what we call a common law system of law, which follows precedent. And what is precedent? Precedent is that an earlier case is regarded as an example or guide to follow unless the case is substantially different in facts and in law from the case that is before you. In this particular case, the BG versus AG case, there were at least at the time of hearing 3 similarly decided cases, and subsequent to the hearing, and hearing I mean the day that we went to court to give arguments on the matter. And as of now, there are 4 cases. There is the case from Trinidad, there is a case from Belize, there is a case from Antigua, and there is also a case from St. Kitts and Nevis. Now, with those cases, they were all constitutional challenges as well. And the challenge was whether or not Section 14 and 16 of the Sexual Offences Act contravened the rights of the individuals. And the different cases had different prongs of arguments. But for the purposes of our case, their arguments range from the section prohibited the freedom of association, it discriminated based on gender or sex, sex, and that the right to privacy by virtue of the section just being on the books were infringed. And for our case, the state set out that Section 14 and 16 did not contravene the protection to personal liberty. It is not in contravention against the protection against inhuman treatment. It is not in contravention against the provision to secure protection of the law. That was how the state presented its case. We also indicated that not every complaint that is covered under Section 14 and 16 contravenes the Constitution, and there is value in protecting persons who do not consent and protecting minors. And minors, for the purposes of Dominica, are persons under the age of 16. The offense of buggery, as the minister has indicated, still remains on the books. The case has only qualified who it applies to and who can be criminally charged. And I would like to restate that decriminalization is not legalization. Decriminalization simply means that you will not face a criminal charge for the offense. And who in this context will not face a criminal charge for the offense? 2 consenting adults in private. When one adult in private does not consent, and the adult that does not consent, decides to make a report to the police under the law is empowered to investigate it. Where a minor is subject to the act, a minor in law cannot consent, and a complaint is made to the police will investigate it and is empowered under the law to investigate it. In our circumstances, it was practical and in the interest of administration of justice as officers of the court to be aware of the precedents and to note the precedents, and despite whatever personal views we may have on the matter, to follow the precedents. I would like to restate that Dominica is a moral society, it is a religious society. The legislation, the case does not prevent you from exercising your choices as a Christian or whatever denomination that you subscribe to. At the end of the day, these are personal choices, and the Constitution protects persons' rights to exercise their personal choices. It is important that we are respectful as citizens of other persons, whether we agree or we disagree with how they choose to exercise their choices. That being said, I would like to emphasize that in this case, the court did agree with the Chamber's position that the law did not infringe anyone's rights as it relates to their security of person. It did not infringe, and the state, the police, does not infringe the rights of persons as it relates to discrimination based on sex, the law as it stood then and the law as it stands now. And the law does not infringe the right for freedom of association. I say all that to say the claimants presented the case that they wanted a declaration that the law prevented them from freely associating, that the law discriminated against them based on their sex, and that the law prevented them from having a right to security of person. And the court ruled and decided that that is not a correct interpretation of the law. The court, however, did make the concession that the Constitution guarantees persons the opportunity to exercise their rights in private once there is consent. Now, I wish to end by saying it is important to remember that this is not a claim about moral rights. This is not a claim about personal choices. This is a claim about the Constitution and what rights the Constitution could properly protect in a society as it changes. Thank you.
Thank you, Mrs. Sober Joseph, for your presentation. We will now call on the Director of Public Prosecution, Ms. Shona Dairampo.
Good afternoon, all. I wish to adopt the protocol established by the learned acting Solicitor General. The role of the Office of the Director of Public Prosecutions in this realm of things right now is to prosecute matters pursuant to the Sexual Offences Act. But the first question I asked after I heard the judgment, has this judgment changed the social context of Dominican society? Yes, concessions, as the learned Solicitor General indicated, so concessions were made, certain rulings were made by the court in respect of the legislation. But has the social context changed? Has the way things been operating changed so drastically? When I saw the headlines, burglary laws banned, was that really what the case said? Now, the social context was that for us to prosecute sexual matters, for example, burglary, you must have a victim. So if we had matters where they were consenting adults, they would never be brought to the court. Actually, in the case, it is acknowledged at paragraph 9 that there were no burglary matters where before the court in which consenting adults were involved. I have been at the Office of the Director of Public Prosecutions from since 2012, and I've never seen a matter of burglary where it involves consenting adults. These matters, burglary matters, are usually brought in the context of where it's a minor who cannot give consent or where an individual does not consent to that act. So really, yes, the court has made certain rulings so that the law can be kept within the confines of the Constitution. But at this stage, I would say that the social context itself in Dominica has not been changed by the rulings. So don't be scared. Don't think that, what the moral standards that you hold are no longer existing because of that particular case. Now I'm going to take you through the particular sections. Burglary is pursuant to section 16 of the Sexual Offences Act. And this was one of the sections that came up for discussion in the case. Section 16 defines burglary as sexual intercourse to anum. And what has happened now is that the court is basically saying that where burglary is committed between two consenting adults, that is a man and a woman and a male and a male, that within the privacy of their homes, there's nothing illegal about that, which really what was happening in Dominica. We were not prosecuting these matters. We have never prosecuted matters of that nature. Prior to the ruling, burglary between consenting adults, be it male and female, male and male, was illegal. Right now, it's decriminalized to the extent that between consenting adults, we cannot prosecute these matters. Now, we still have burglary on the books. The act of burglary in respect of a non-consenting adult. And now, members of the public have met me and they've been asking, what happens to convictions that have been obtained? Because as of recent, the Office of the Director of Public Prosecutions prosecuted over the past 2 years 2 burglary matters, one of which involved a minor, the other was a non-consenting adult. And so is this case going to be quashed? Is this ruling going to be overturned in keeping with the case? No. Solely because what the way in which the law has changed is in respect of consenting adults. So matters we've had before in respect of minors, where adults were brought before the courts for committing the offense of burglary against a minor, or someone was brought before the court for committing the act of burglary against an adult who has not consented. These matters are safe convictions in keeping, because it's in keeping with the recommendations made in the case, the constitutional case. Now, burglary, a lot of people may want to know, what is the penalty for burglary? Burglary against a minor is 25 years imprisonment, custodial. The minister indicated that the court does not have a discretion when it comes to that. The Sexual Offences Act is one of the most robust, if not the most stringent Sexual Offences Act in the Commonwealth of the Commonwealth Caribbean is Dominica's Sexual Offences Act. It was amended in 2016. And for burglary, you can get a sentence of as high as 25 years imprisonment when it is committed against a minor. When it is committed against a non-consenting adult, you can get up to 12 years imprisonment. So the sentences are very strict and the sentences still remain. The only minor concession, I would say, is that consenting adults in the privacy of their home, they can engage in the act. That's not our business. But where it comes to an act being committed against a minor, these matters will be investigated by the police, will be prosecuted. Where it's a non-consenting adult, they will be investigated by the police. Now, we also have the act of gross indecency, which is governed by Section 14 of the Sexual Offences Act. One may wonder, what is gross indecency? And gross indecency is basically someone performing an act, whether natural or unnatural, by a person involving the use of the genital organs, breasts, or anus for the purpose of arousing or gratifying sexual desire. This, too, has very stiff penalties, but the case only indicated that in respect of gross indecency, where you have individuals doing it in the privacy of their home and they're consenting individuals, it's okay. And again, as I said, we have to consider the social context. Have the police been rushing into people's homes to see what they're doing in the privacy of their homes or in their private settings? No. These matters were only being brought to court when they were being done in public. when a minor was being violated, when a non-consenting adult in public was being violated. Now, the act of gross indecency, where the complainant is a person 16 years of age or more, the sentence is 12 years. And where the individual is a minor, where you have a victim who is a child under the age of 16, the sentence is 20 years. So these offenses carry very severe penalties, and the case, this decided case, has not changed anything in respect of the penalties for these offenses. They remain as is. Even so, for the act of gross indecency, it has been qualified to the extent that the individuals have to do it in their privacy, their private settings, their home. It does not, if it happens in a public setting, matters will be prosecuted. So when individuals say that, the case said that gross indecency is legal now. When I go to a public area, can two males engage in their act? No. This cannot be done because it's not within a private setting. And at the end of the day, we can never prosecute something that is done within a private setting, a sexual act done within a private setting, unless there is a victim. Someone is saying, I did not consent, or the person is a minor. The individual is a minor who does not have the right to consent. If an act is being done in a public area, an act of gross indecency, an act which covers the elements of gross indecency, the police have every right to investigate and prosecute. So it's not the case where all decency in the Commonwealth of Dominica has gone down the drain, as some of the headlines may try to indicate or bring forth. It is a matter where the court is saying internationally, because into cases on the international plane will also refer to cases coming from the US, from Botswana, that the society is moving to that particular, being liberal in respect of that and understanding the law that certain people have rights. There's a group of people that have rights, they consider to have rights, but these rights, their freedom of expression, cannot be forced on members of the public that do not, or the members of society that do not subscribe to that concept. And it's not something to say it's only in the Caribbean that it's happening. From the case, and I would encourage members of the public to read the case before considering the headlines that are out there. Sit and read the case, because it's very easy to understand, and it explains clearly why that particular decision was taken, that certain sections of our act has to be amended in the sense of to allow consenting adults to engage in the act of burglary, and also to allow consenting adults in the privacy of their homes to engage both in burglary and in gross indecency. So, in closing, I would say, read the case. You'll understand why the court, clearly why the court gave that particular decision, and you will understand why the first thing that was said by the minister today is that burglary has not been decriminalized. Okay? It is, we allowed in certain circumstances, certain concessions have been made to engage in the act, but it's not a matter where everything has been thrown out from the books. It's no longer on the books, burglary is no longer on the books, and that's it. No. It is still remains an offense. Burglary still remains an offense in the Sexual Offences Act, Chapter 1036, where the maximum penalty can be 25 years. Gross indecency still remains on the books. And in keeping with these two sections, I would say that there are other sections that also assist in understanding our social context. We also have the sections of grooming, which was not there prior to 1998, when you encourage children to partake in certain sexual activities, minors, that is, to engage in certain sexual activities. An adult, can be prosecuted for that. So I think too that was a concern of the public, that can individuals who engage in burglary, acts of burglary, force that on to minors? No, it cannot be done. They can be prosecuted if it is done at all. As of under the Sexual Offences Act, we have gross indecency, we have defilement, we have rape, steal. So there are very serious offences under the Act with strict, very high custodial sentences attached to them. So there has been no breakdown of the law in respect of the sexual offences of burglary and gross indecency. Just minor concessions which were given by the court.
Thank you, Ms. Dalrymple, for this presentation on sections 14 and 16 of the Sexual Offences Act, Chapter 1036. We would now like to open for questions from the press.
So do you intend to do that? The next question is that a lot of people are worried that this amendment will lead to same-sex marriage. So can you address that? As well as, did the court or the ministry meet with the Christian Council before amending the...
Thank you very much for your question.
I do not propose to answer all the questions, but I can start with the last question. To clarify, the Constitution has not been amended. The law, the Sexual Offences Act, Sections 14 and 16, have been qualified or modified to be read in such a manner that the blanket criminalization of every act is no longer the case. The only thing that is allowed, consenting adults, male, male, female, female, male, female, in private. But the Constitution is not what has been amended. The section in the Sexual Offences Act is what has been amended. I do not recall what the second question was. As I indicated earlier, whether or not same-sex marriages will be legalized is a question for the policymakers. It has been reiterated that we are still a God-fearing society, and predominantly we know what the Bible says. As it relates to whether it will be, that is not within my purview, but what I could emphasize is this case does not legalize same-sex marriages. The ruling in this case does not legalize same-sex marriage. It also does not legalize burglary. It also does not legalize gross indecency. What it has said that two consenting adults in the privacy of their home can engage in the act and they will not be criminally prosecuted. As it relates to the town hall question, I will defer to the Honourable Minister on that.
Okay. I want to commend you again, Mrs. Sobers, for speaking like a real politician. Just to say on the issue of town hall meetings, as you know, that's just a second attempt by the ministry to edify the public on the actual ruling itself. Days after the ruling, we had a program almost 2 hours on the nation station, expressing the real facts. And that is why we're here today, to continue that effort. I think there's merit, what you have said, on the town hall engagement. That is why I think that each one of us here has a responsibility to engage the public and then to disseminate the information via various platforms, social platforms, and also radio to the public, and within the schools and churches, etc. So that's a good thing. Insofar as same-sex marriage is concerned, and I'm happy that reference was made to the issue of discrimination insofar as sex is concerned. And our Constitution is written in a way and guided by the principle, Christian principles. And so gender within our confines of our laws, in our society, a man and a woman, right? And marriage, a man and a woman. And so that ruling has nothing to do with same-sex marriage. What I can say to you, what the government has done was to have gone to Parliament and passed the most sweeping amendments in the Sexual Offences Act. This is the court. This is the court based on a challenge that qualify certain elements within sections 14 and 16 as it refers to two consenting adults. And these are the operative terms, eh? Two consenting adults within confines of privacy. Let us suppose hypothetically, if Tom was an adult, invite Gary, I don't know call anybody, okay. John Brown was an adult at his home with a braff. And during eating the braff, he gave the other guy some rum, guy charged, and he decided to go that to him. That is not permissible by law. This is buggery if that were to happen. Even if they're two adults. One didn't consent, one was induced, one was, whatever the case may be, one was forced. Do you understand what I'm saying? Even if it happens within the confinement of privacy, the adult has to consent. So that has nothing to do with same-sex marriage. And insofar as domestic laws are concerned, in terms of making provision for that, what we have done as a responsible government, mindful of our Christian values, is to pass laws to prohibit the engagement of those kind of sexual or natural activities, whether it were to consenting adults within the privacy of the home. That's how far we are gone. Okay? Right? Nothing. And that would be a difficult one to expect. Any change to our laws to give effect to same-sex marriage. As I've said, reiterate, this is not a lifestyle that I subscribe to, and I'll never subscribe to. But we have to be adult enough to appreciate we live within the powers. And the court has ruled, a challenge has been brought. We have to accept it and do not go out violating or seeking to black eye anybody. I wanted to say further. We always point fingers at the politicians. Rightly so. We take our blows, that's cool. But we set aside our individual and collective responsibility in the society. Look at this. We went to Parliament 2016 and overhauled our Sexual Offences Act for the express purpose of protecting the most vulnerable in our mix, especially minors, children. And the law that we have passed places an obligation on parents, teachers, guardians, doctors, nurses, to report any such suspicion or act of sexual violation on a minor. And then you can be held liable, criminally liable under the law. If you're a teacher, if you're a parent, a guardian, or somebody who has been entrusted with the care of a minor and not reporting that to the police. That's how far we have gone, to Parliament. And then it will turn back and blame the politician for not reporting incidences where you have an obligation by law so to do. The last thing I want to make a reference to, all right, because some people are very good in getting upset and they go on social media and say all kind of different things about the Prime Minister, about ministers, instead of trying to get themselves educated. And hate never solve any problem. So even if you go and have multiple press conferences, as people some people have their own methodology and reality, they're going to believe what they want. My last one I want to make before you go to the next question, and I am very much concerned about that, is the issue of incest. Whereas we speak a lot about two adults within the privacy of the homes, doing something that most of us don't agree with. And most of us, a lot of us don't agree with the court ruling. Do you understand what I'm saying? A lot of us don't, but we have to be adult enough to understand how the legal system works. But we have under Section 6.1 of the Sexual Offences Act, the issue of incest, which is to me one of the most animalistic and diabolical acts that can be committed within any society. And the law goes as far as to demarcate when such an offense is committed. Father, parent and child, brother and sister, uncle and niece, grandparent and grandchild. That's what the law says. But it has been condoned, and they blame the politician. You understand what I'm saying? The law is there, and it places an obligation for people to report those things. These are all the things that this government has done, So we have to be mindful that while we're pointing our fingers at people, the form is back in our faces. And this element of hypocrisy that we have to address frontally. This Sexual Offences Act is comprehensive in scope and demonstrates the intention of Parliament, the intention of the executive cabinet went to Parliament and to pass those sweeping pieces of legislation to protect the vulnerable economics, the minors and non-consenting adults. And there's a next segment of people I want to talk about who's also protected. I'd like to tell him, even as a police officer, MBC. We call them the dumb, deaf and dumb people, etc. They cannot give consent. Even if they were to say yes, they cannot give consent. And you would do that to them, even if they're adults, that's an offense. Do you understand what I'm saying? All like to have covered, So it's important for us to understand this thing, and I believe that is why we have started the program within the ministry second Thursdays and last Thursdays of the month. I think we should engage other programs to educate the public on these fundamental issues of law, and they can know their rights and their responsibilities. And this Sexual Offences Act places a legal responsibility to report on many people, not the politicians, not the Prime Minister. We have a responsibility, brothers and sisters, collectively, to address those things that happen in society. It's one thing to go on social media and just, you have nothing to do. You have not read anything and just posting all kind of hate and stuff like that. Another thing to be a Dominican, to be an adult, The conscience. You do get my point. The conscience. And no one with a conscience can engage in sex with his daughter, his grandchild, his niece, his granddaughter. So it's not only that. We have to look at the Sexual Offences Act in its global sum. And those laws are on the books. Unless if some of us want, only the Minister, National Secretary, and the General and the Prime Minister to come and knock on people's home. What are we doing now? You have anybody you commit any acts against the man, or force anybody inside them? You have a responsibility because it's at the home. That's how society works. And I can tell you, I know it feels. Look, Mr. Valera was there. He's Commissioner of Police. He used to call me Sergeant before. We said it together. Before we had the abundance of female police investigators, a number of us did sexual offenses, including myself. I can tell you the impact it has on a minor. That child is never the same again. And it's been condoned, you understand, by homes, by adults. Those are the things we have to address. And notwithstanding everything I've been said about me, I have no regard and respect for any man who interferes with a minor or raises his hand on a woman. For sure. Absolutely no regard. That is what we have put on the books. We have a whole. I want to really call out and shout out my partner, Mr. Riaris, a great Dominican. Sat down and had consultation with whatever groups and overhauled the Sexual Offences Act to the extent to which people told us we were violating people's rights under the Constitution. And for the extent to which, when I went to Parliament, I don't call names, but some pastors and priests were messaging me and telling me we're going to allow women to take the foot on men. Because how can once a woman married to a man, she cannot say no. Can you imagine that? And that's why I started saying to myself, I'm going to start going to church less. Okay, man? I'm going to start going to church less. But if a man has it in his psyche, a woman cannot say no. You understand? Because they're married. You know, we have a fundamental problem as to how you see a woman. You do get my point. But the point for folks like myself, because we work, you understand? Any man will believe that a woman is inadequate to him. No regard. Because we have been there, investigating those matters. And today I'm happy to be part of a government who is taking a very strong and serious stand on that. That notwithstanding, those who are doing nothing want to point their hands and fingers at the Prime Minister and the administration. This is not right at all. You have a right to criticize us for policy matters, it's right. But don't just everything does bliss us just like that. For no reason. Okay, I think I've spoken enough, so let's continue, please. Thank you.
It has been suggested over there that some people have now sued as a result of external pressures. We saw the Samoa agreement just been signed in Brussels. Can you speak to that?
Well, obviously, I mean, there's merit to an extent to what you're saying. There was outside pressures, and the agreement, insofar as having an impact on the domestic legislation, is almost inconsequential. You get my point. There's no inclination, from what I know, and as the Minister of Legal Affairs and the only Prime Minister, what we're going to amend our domestic laws to give effect to same-sex marriage and other issues, to be quite honest with you. And we define gender as a man and woman. And we have a responsibility, as I made reference to the foreword of our Constitution, founded on the principles that acknowledge the supremacy of God. See? And that is how all laws have been crafted going forward. So we also appreciate that the world is changing, and there's certain things that we have to adjust to, but it's a different mindset when it comes to go into Parliament and adjusting our laws to give effect in a value system that we would not subscribe to.
Will it come down to a point? Will it come down to a point where we will see in the laws where a gay couple might be able to adopt a child?
Well, at the same time, that's a hypothetical question that I don't want to answer at this point. My focus right now is the reality now that we're speaking about. Let me just say something to you. I mean, we have learned a lot. I went to school in Canada, both university and college. And this is a country where you have issues of sexual orientation. And I had absolutely no problem with anybody. Everybody knew where I stood. You get my point. And I'm not the kind of person who go into actually folks with that kind of lifestyle. We did group projects together. They knew that whole end. And I hold my hand. But I don't want to get myself involved in blacklining somebody because the person chooses to do what he or she wants to do as an adult. You understand what I'm saying? I don't want to get myself involved in that. When Christ, when the young lady was brought before Christ and for committing adultery, and then in those days, the punishment that the woman would have to have been stoned to death. And he has done a very simple question. He who has not sinned cast the first stone. You know what they did? They looked at him and they turned their back. Because then all of them had sinned. So the reason why I'm saying that, even if we do not subscribe to a lifestyle, I don't subscribe to it. We have to be careful, you understand, that we do not sweep certain things under the rug. Incest, you understand? The people reluctant to report the sexual abuse of minors under the care. You understand what I'm saying? That? And then we just focus on one issue. But we have to look at the global sum, Mr. Talent. I can recall doing a matter. And then the father was the stepfather of the child. Next thing, not far from where the financial center is. Next thing, a couple months after, the mother was vexed with me. Because she put the welfare of the man over the life of that young child, who was about 80 years old. You get my point? I'm not saying, folks, listen to me well, that we are involved in theater to an extent when we are acting, and we're not addressing some of the things that we ourselves need to address. For us to actually ensure that the Sexual Offences Act in totality is properly effective, and is effective, we have to play our part by reporting people who are under our care, who have been violated by our boyfriends, by our husband, or anybody. Incest. You see, understand that? Not having an understanding of our human biology and the impact it can have on society. We have a number of children having Down syndrome. That's what I'm saying? When you have father and daughter involved in sexual intercourse and giving rise to children, this has an impact on society. And it impacts on the health system, the healthcare system. We have to understand those things. So I'm happy having a discussion, and the whole idea of having town meetings with the technicians going out and explaining that around the country, I think it's something that is very, very, very noteworthy and needs to be explored. Any other question before? From you? Any other question? I'm gonna give credit to Jess, is that so? So because if I were to say about green pathway as a word I don't want to really say. So I'm not figuring out where to say it. So I prefer to yeah. So I'll do give yeah. Thank you very much, folks. I think you guys are very professional. Have a nice day, and we'll continue the engagement. And that's all. The second time we're doing that, I will continue engagement. Yeah. Before you go, let's.
A special good morning to our viewers. We would like to thank you all for staying tuned for this press conference here at the conference room of the Financial Center, where we were able to get some clarification on the recently passed bill regarding the decriminalization of burglary. We'd like to thank you all for staying tuned in, and remember, every moment online with MO News. Thank you once again for staying tuned, and have a wonderful day.